Key Employment Law Cases of 2022. Pat Harrington, General Secretary of Solidarity, looks back at some key employment law cases from 2022. These cases include Usdaw v Tesco Stores Limited, in which the UK Court of Appeal ruled that Tesco could proceed with its plan to fire and rehire employees, removing a contractual pay benefit. Forstater v CGD Europe, in which an employment tribunal ruled that gender-critical views, which hold that sex is an immutable biological fact, are protected under the Equality Act 2010, and that discrimination and victimization based on these views is illegal, and Macrith v DWP, in which a Christian doctor claimed he was subjected to discrimination due to his beliefs about transgenderism, but the Employment Appeal Tribunal ruled that the DWP had not subjected the doctor to less favorable treatment. These cases highlight the challenges faced by employers in balancing the expression of personal beliefs in the workplace with addressing complaints and concerns from colleagues, and the importance of clear policies on internet and social media use.
Usdaw v Tesco Stores Limited. The United Kingdom's Court of Appeal ruled that Tesco Stores can proceed with its plan to fire and rehire employees, which would remove a contractual pay benefit. Tesco had offered its employees a lump sum equivalent to 18 months of pay in exchange for giving up the regular benefit, and threatened to dismiss and re-engage them if they did not agree. The United Kingdom's Usdaw trade union sought an injunction, arguing that the employees' contracts contained an implied term preventing Tesco from exercising its right to terminate employment for that specific purpose. The High Court granted the injunction, but the Court of Appeal has now overturned that decision, stating that it was not appropriate for an injunction to be granted for an indefinite period preventing Tesco from dismissing employees. Forstater v CGD Europe. In this case, an employment tribunal has ruled that gender-critical views, which hold that sex is an immutable biological fact and that trans women are men, are protected under the Equality Act 2010 and that discrimination and victimization based on these views is illegal. Ms. Forstater, a visiting fellow and consultant for CGD Europe, an international development think tank, held these views and expressed them on social media, leading to complaints from her colleagues. CGD subsequently decided not to renew her fellowship and removed her profile from their website. Ms. Forstater brought claims of philosophical belief discrimination, indirect discrimination, harassment, and victimization to the Employment Tribunal. The tribunal ruled that Ms. Forstater's social media posts, which expressed her beliefs, were not inappropriate or objectionable and that CGD's decision not to renew her fellowship constituted direct discrimination. The tribunal also found that CGD's removal of Ms. Forstater's profile from their website was an act of victimization. This case highlights the challenges employers face when dealing with the expression of personal beliefs in the workplace, and the need for a careful balance between respecting an employee's protected beliefs and addressing complaints and concerns from colleagues. It also serves as a reminder that social media use by employees can have significant consequences, and the importance of having a clear policy on internet and social media use. Macrith v DWP. In the case of Macrith v DWP, a Christian doctor named Dr. Macrith claimed that he had been subjected to discrimination due to his protected beliefs about transgenderism. Dr. Macrith believes that a person cannot change their sex or gender at will and does not believe in transgenderism. During his training for a role at the DWP, Department of Work and Pensions, he made it clear that his beliefs would prevent him from using the preferred pronouns of transgender service users, which conflicted with the DWP's internal policies. The DWP determined that there was no alternative to Dr. Macrith having to work with transgender people and his employment ended when he chose to leave. The Employment Appeal Tribunal, EAT, ruled that Dr. Macrith's beliefs and lack of belief met the necessary criteria to be considered protected under the Equality Act, similar to the beliefs held by Ms. Forstater in the previously discussed case. However, the EAT also ruled that the DWP had not subjected Dr. Macrith to less favorable treatment because of his beliefs, and that any health assessor in the same situation would have been treated the same way. The EAT also stated that the requirement to use the correct pronouns was a necessary and proportionate means of meeting the DWP's aim of focusing on the needs of potentially vulnerable service users. Dr. Macrith has appealed the decision to the Court of Appeal. The EAT also confirmed that the threshold for establishing protection for an employee's beliefs under the Equality Act is low, and that even offensive beliefs can be protected as long as they do not destroy the rights of others. Miles v. Royal Veterinary College. A recent employment tribunal in London Central has ruled that a belief in ethical veganism can be considered a protected, philosophical belief under the Equality Act 2010. However, the same tribunal also ruled that a belief that there is a moral obligation to take positive action to reduce animal suffering, including trespassing on property and removing animals, is not a protected philosophical belief. The case involved a veterinary nurse who was dismissed from her job after a sick turkey was found at her home. The tribunal ruled that the nurse was not discriminated against in her dismissal. This decision supports previous rulings on the definition of a protected philosophical belief, and highlights the potential difficulties in determining what constitutes a protected belief under the Equality Act. DWP v. Boyce. The Employment Appeal Tribunal, EAT, has ruled that the dismissal of a disabled employee after a period of prolonged sick leave was discrimination arising from disability. The employee, who had chronic migraines, anxiety, and depression, claimed that these conditions were exacerbated by bullying and harassment by a colleague. Although the employee was given the opportunity to work at a different location, the EAT found that the employer did not properly implement the trial or evaluate its success before deciding to dismiss the employee. As a result, the EAT concluded that the dismissal was a disproportionate response and that the employer could not objectively justify its decision. This case serves as a reminder that before dismissing employees protected by UK disability law, employers should consider alternatives to dismissal and be able to justify their decisions based on legitimate aims. Singh v. Metro Line West. In a recent case, the Employment Appeal Tribunal, EAT, ruled that the dismissal of an employee who had been absent due to illness was a form of constructive unfair dismissal. The employee, who had been denied company sick pay, had resigned after their employer failed to comply with a term of their contract. The EAT emphasized that once a fundamental breach of contract has been established, an employer's intention and reason for breaching the contract are irrelevant. This case serves as a reminder that before dismissing an employee, employers should consider alternative options and be able to justify their decision as meeting any legitimate aims. Sunderland v. Superdry plc. An employment tribunal ruled that the clothing company directly discriminated against a 56-year-old knitwear designer, Ms. Sunderland, during its performance review and promotion processes. Ms. Sunderland brought several employment claims, including unfair dismissal and age discrimination, and highlighted 8 colleagues, 7 of whom were younger than her, who had been promoted or hired into senior or lead designer positions ahead of her despite her favorable performance reviews. The tribunal found that the criteria for promotion were flawed and left key elements undefined and ambiguous, leading to Ms. Sunderland's direct age discrimination claim being upheld. The tribunal also determined that the flight risk aspect of the performance assessment process, which considered whether an employee was likely to leave the company and the impact of their departure, was based on nothing more than managerial conjecture and was likely to disadvantage older people. As a result, Ms. Sunderland was awarded approximately £96,200 in compensation for financial loss, a basic award, injury to feelings, and interest. This case serves as a reminder of the importance of adopting clear and objective performance criteria for appraisals and promotions, and maintaining a detailed paper trail to support decision-making and defend against allegations of discrimination. Burke v. Turning Point Scotland. Disability Discrimination, Long COVID, an employment tribunal, ET, has found an employee suffering with long COVID to be disabled for the purposes of the Equality Act 2010. Although not all long COVID sufferers will be disabled, it is a reminder that the associated symptoms are potentially capable of meeting the definition. In this case, it is also noteworthy that the tribunal was satisfied that the test of disability was made out, notwithstanding that 2 occupational health reports obtained by the employer suggested otherwise. Harper Trudy v. Brazel. The Supreme Court in the UK has ruled that holiday pay for part-year workers, such as teachers, should not be prorated. In the case of Harper Trust v. Brazel, a music teacher named Ms. Brazel claimed that the Harper Trust had made unlawful deductions from her wages in relation to her holiday pay. The trust had changed its method of calculation in 2011 to pay Ms. Brazel 12.07% of the hours, She worked over the relevant term, but Ms. Brazel argued that this calculation was incorrect for a part-year worker because it resulted in weeks where she was not accruing holiday while still under contract. The Supreme Court ruled in favor of Ms. Brazel, stating that holiday pay for part-year workers should be calculated using the method outlined in the Working Time Regulations 1998, which averages pay entitlement over a 52-week reference period. This decision is expected to have a greater impact on sectors such as education, and may require employers to review their approach to holiday pay for part-year workers to ensure compliance with the law, and to account for the potential commercial impact of higher holiday pay rates.
Thanks to listening. If you like this content and want to hear more, please consider subscribing to our channel. Music in this podcast is from Tim Bragg.